Hi, everybody. In this lecture, we're going to talk about contract law. I'm going to give you kind of an overview of some of the basic rules on contracts in Japan. So in terms of content, first I'll just give you a brief introduction to the question of what is a contract. And then after that, we'll look at a few rules in the Civil Code. The Civil Code contains kind of the basic structure of the basic rules on contract in Japan, and we'll go through the different types of contracts, formation, how do you make a contract, performance of obligations, like a contract is one person promising to do something for another. In other words, they're promising to perform an obligation of some sort. Sometimes there's issues that come up with like one party not doing what they were supposed to do, or something like that. So we have rules on that. And cancellation. How do you cancel a contract? And at the end, I'll go over a few cases that illustrate some of these different rules. So let's start off by asking the question, like, what is a contract? I mean, in basic terms, and this is not just in Japan, but in pretty much any country, a contract is a promise for a promise that is legally enforceable. Like if I promise to do something for you, like we could have a sales contract where I sell something to you. I promise to give you the thing, you promise to pay me, and we don't necessarily say like I promised you, but that's what it is. That exchange of obligations forms a contract, and it becomes legally binding. Like if I fail to do what I did, but you did what you did, you can sue me. Now, in the Civil Code of Japan, there are different types of contracts, and there's different rules that apply to each of these. I've actually you don't have to memorize this. I've just listed all of them here. Like, for example, there's gifts are a form of contract in Japan, not in my country, or a contract of sale, an exchange, leases, employment. There's a few of the main ones right there. Some of the rules that apply to each of these are different from each other because depending on the type of contract, maybe the nature of the contract, the exchange of promises is different, and the issues that come up are different, so they have to have special rules. So I won't go through these. There's way too much. But I want to introduce you to like the general principles that apply to like basically all of the different types of contracts which the code has. So one basic rule, this is actually not stated in the Civil Code, but it's recognized under Japanese law, is the concept of freedom of contract. Freedom of contract basically means that, well, contracts are something that you voluntarily enter into. You shouldn't be forced to enter a contract. There is one exception to that, which is the NHK contracts in Japan. If you own a TV, you're required to enter a contract with like the national TV broadcaster NHK and pay them like an annual fee. Because it's required of you to do that, it's not really a voluntary thing, but it's still called a contract. So that's kind of like an exception. But the main that's one element of like what we would refer to as freedom of contract. The other one is that the main one is that the terms of a contract are open to whatever you want. A contract is something that you, in theory at least, that you negotiate with like whoever you're making a contract with, and what you're promising each other, what obligations you have, like what rules you're going to impose on each other. That you're free to decide that with the other party, whatever you two agree on, or it could be more than two, but for simplicity's sake, we'll say it's two. That's fine as far as the law is concerned. So if I want to sell you my car, actually I don't have a car, but let's pretend I do. All of the terms of our agreement are basically up to the negotiation between you and me. Like, what's the price? What's the delivery date? Do I make any warranties about the condition of the car? Like if I say, oh, this car is in really working order, and then you find out it's not, like as soon as you start driving it, it breaks down. Are we going to put some rules in the contract that give you like the right to, for example, demand a refund if it doesn't work, or something like that? So all those terms are things that we can decide on our own. Now, In practice, like this is what we call a default rule. It's in practice, we can't always leave everything to two parties to negotiate, right? Like if I negotiate to do something illegal with you, for example, the law doesn't want to enforce contracts to commit a crime or something. Like if I hire you to go like rob a bank or something. So there are limits on freedom of contract. But in general, that's kind of like the background provision. And with certain types of contracts also like that are legal, we do have like areas of law that also put minimum standards. We'll talk about in another lecture I'll do here. Employment law contracts or consumer law contracts, where one party is kind of like weaker than the other. Maybe sometimes the law says, well, we don't really want to leave it fully up to this freedom of contract thing, because sometimes one party will have like a lot of bargaining power in that actual negotiation, and they might use that to abuse like the other party. And actually, like in your everyday life, you've probably the vast majority of the contracts you enter into in your life are not ones that you negotiate. They're ones where it's like a take it or leave it kind of deal. If you go to a convenience store to buy something, you're making a contract when you buy something. I mean, you don't sign any paperwork or anything, but that's what you're legally doing. Like when you buy a bottle of Coca-Cola or something, you don't negotiate that. the store says, it has a price tag on it. This is the price. If you want it, take it. If not, whatever. There's no negotiation that takes place. But also like that's like a simple sales contract. But also in things like if you have a cell phone, or you have like an internet provider, or some kind of contract where you're dealing with like a big company that's selling something, there's often they will present you with a written contract when you sign up for them, or if you're doing it online, there'll be like the online version of that. Which can be very, very long and contain like dozens or hundreds of terms and conditions that are entirely written by that company. And none of these things are negotiable. They define things like, what rights and obligations you have, what rights and obligations they have. Usually they don't put too many on themselves. And you just, you click an accept button, or you're asked to sign the form in the store. Maybe you read it, maybe you don't, probably not most of the time, because who has time for all that? But those are contracts that you're entering into with no negotiation. And because you're a consumer, and this is like, a cell phone contract is something you don't do very often, right? You sign up for a cell phone and, you can keep the same one for years without ever having to like renegotiate, or not to enter into a new contract. Cell phone companies, on the other hand, they enter into cell phone contracts, like millions of them, like all the time. They have a lot of experience with it. They know exactly what terms and conditions they want to put into that contract, and they will put what they can that benefits them. For that reason, you as a consumer, and I'm just using consumer contracts as an example, that bargaining power is very, very different. So sometimes the law will step in and say, okay, to use the cell phone company example, we will put minimum standards that you cannot put some things into your contract. Yes, like freedom of contract is like a principle that we recognize, but we can also recognize that this is like a type of contract, a specific type of situation where this unequal bargaining power puts one party at risk of being abused, of like unfair conditions or something being put into a contract. So there are some exceptions like that, employment law, consumer law, and a few other areas. But outside of that, the freedom of contract is sort of like the background rule, but there are exceptions to it. So I'm turning to the Civil Code now. The code contains, at the very beginning, Article 1, certain fundamental principles. I'll just read them here. Article 1. 1, private rights must conform to the public welfare. 2, the exercise of rights and performance of duties must be done in good faith. And 3, no abuse of rights is permitted. These are fundamental principles of law that apply to everything in the civil code. Like all, not just contracts, but like all other things like tort that we talked about last week, it was last week. And when I recorded this was last week, and other areas. But in the realm of contract law, these general principles that apply to like all legal acts that people do in their in their lives. These are sometimes used by courts in interpreting the provisions and obligations that might be contained in a contract. We'll look at a case that deals with some of these towards the end. Particularly, no abuse of rights is permitted. That one, in the contract law field, that's usually like contracts will tend to give parties rights. Like I have a right to demand that you pay me because we have a contract, you're supposed to pay me, or I have a right to a refund, or whatever right you put into a contract. Sometimes though, like somebody who has a right that's stated in a contract, there might be situations where that party insisting, like, this is my right, I'm going to enforce it against you, might, in the circumstances, result in something that's very, very unfair to the other party, or well, yeah, usually to the other party they're demanding it from. Sometimes people can use this provision to argue that, okay, yes, we have a contract, that party does have a right against us, but in these given circumstances, it would be very, very unfair. It would be like an abuse of rights for that party to enforce it, and we're asking the court to not do so. We saw in an earlier class on family law, we saw like a case, it was not in a contractual dispute, but where the same provision I'm talking about, abuse of rights, was referred to with the divorce case, where one of the divorce cases where I think it was the mother, there was a settlement of a divorce, and the husband had agreed to pay like child support for like 4 children, and afterwards, like, it was discovered that, oh, one of those children was not yours, like the mom had an affair, and so on the contract, the father had, actually that was a contract case because it was a family law case, but they had reached an agreement, which is a form of contract, on how they were going to handle their divorce, and the father had agreed, yes, I will pay child support, like a certain amount of money each month to support these 4 children. But the court found that, yeah, okay, technically the mom has a right to enforce that against him. But given the fact that this one child was actually not his, and at the time that they entered this agreement, he didn't know that, and it would kind of be unfair to hold that against them. We're going to declare that the enforcement of that as it relates to that one child would be an abuse of right, and we won't enforce it. So there are a lot of examples where courts will step in to basically to not enforce a provision of a contract against someone when it's an abuse. There's also this other article, Article 90, which is public policy. It says a juristic act with any purpose which is against public policy is void. This is another provision that applies to everything in the civil code, not just contracts. But this is another one where another provision the courts can use sometimes, where not because of something that might be like unfair, but where a provision in a contract, because we're talking about contracts, I'll talk about that, might go against public policy, like kind of like what's good for the public. I mean, if you have a contract to do something bad for society, like some antisocial activity or something, this might become relevant. So if you want to form a contract, where do they come from? Very, very simple mathematical formula: offer plus acceptance equals contract. An offer is, in simple, it doesn't have to take any sort of like form. It doesn't have to be in writing. There's no magic words you have to say. Could be something as simple like, would you like to buy my book for 1,000 yen? And that's my offer. I've stated, the basic terms of our contract: book, money, exchange of obligations, and I've made an offer, and if you say yes or otherwise, indicate that you'll accept it, we have a contract. That it's kind of as simple as that. So like I said, there's no form that this has to take. Could be written. Written contracts are common when there's something more complicated, but many are oral. And yeah, for both of these, there's no magic word like for the offer or the acceptance. Just you have to manifest one of these, either through what you say or through your actions sometimes. So the code, though, does have some specific rules which deal with some of these. So I'll just take you through like some of the basic ones. So Article 521, so this deals with offers. Offers sometimes have a time period. Like if I say, would you like to buy my car for 1 million yen? And then if I just say that, there's no time period. But if I add a sentence where I say, I'll keep this offer open until next Tuesday, I've added like a time period in which my offer is open. So Article 521 sub 1 says an offer which specifies a period for acceptance may not be revoked. So if I've said that, like you can buy, I'll keep my offer open until next Tuesday, I cannot change my mind until next Tuesday. I can't take my offer back. If I didn't put that time period in, then any time before you say yes, if I change my mind, I can revoke my offer. Like if I say, would you like to buy my car? And then before you say yes, I can think about it. Oh no, wait, never mind. I don't want to sell my car after all. If I do that before you've accepted it, my offer basically like poof disappears, and you don't get to make an acceptance, which creates a contract. So you can change your mind. But if you go and say, I'll keep my offer open for like 5 days or a week or whatever, you can't change your mind like that. And so 2, if an offer does not receive notice of acceptance of the offer set forth in the preceding paragraph within the period referred in the same paragraph, the offer shall cease to be effective. So if I say that, I'll keep my offer open until next Tuesday, and next Tuesday comes around and you haven't accepted my offer, then you're no longer able to create a contract simply by accepting the offer that I made. It kind of like poof disappears. So the next one, 523, deals with delayed acceptance. So the offer may deem a delayed acceptance to be a new offer. So if I say, would you like to buy my car for 1 million yen? I'll keep my offer open until next Tuesday. And you don't reply by next Tuesday, but like a day after my offer has like poof disappeared, you come back to me and say, oh yes, you know what? I will take your offer. Because you waited too long, my offer is no longer open to being accepted. But me, like the person who made the offer, when I hear you like kind of purporting to accept my offer, I may treat your acceptance actually as an offer. In other words, I can say, like, legally speaking, your acceptance is actually not an acceptance of my offer. It's a new offer. We're switching roles. You're now offering to buy my car for 1 million yen. And the legal effect of that is that your acceptance doesn't create a contract. It creates an offer. Now I'm the person who gets to decide if I want to accept or not. And if I say, oh, yeah, sure, let's do it, we have a contract. If I say no, then we don't. So this sort of like role reversal can happen. So sometimes the time that our contract is formed, like when does a contract come into existence, can also be an important question. Article 526 deals with time of formation of contract between persons at a distance. So if we're just negotiating like in person, like, and I say, would you buy my car? And you say yes. The contract comes into existence like when you say yes, like once you've accepted my offer. But when we're dealing at a distance, there might be time, like if between, for example, when you send your offer and when I receive it. Sorry, no offer. When you send your acceptance and when I receive it. And what if like sometime between, like, for example, for writing letters or maybe like sending emails, um, like I send you an offer and you send me an acceptance. But between the time you send your acceptance and when I actually receive it, maybe I change my mind and I don't want to have a contract. Um, is it too late for me to do so because you've already accepted it or not? So 526 says a contract between persons at a distance shall be formed upon dispatch of the notice of acceptance. So that means like even if I've made an offer and you've sent your acceptance but I haven't received it yet and I don't know if you've accepted or not, um, uh, I can't go back on it because the time at which the contract was formed was when you sent the acceptance, not when I actually received it, like when I opened my mail and saw it. So sometimes that's an important thing too. Sometimes like we have acceptances which modify an offer. This is, well, I'll read it's Article 528. If the offeree has accepted the offer by adding any condition or by making any other modification, it shall be deemed that the offeree has refused the offer and has made a new offer. What this happens is like, if I make an offer to you, like, would you like to buy my car for $1 million? Or, yeah, I'm kind of making an offer there. And you say, yes, I'd love to buy your car, but I'll take it for 900,000 yen. What you've done there is you haven't actually accepted my offer, which was an offer to sell it for 1 million. You've changed one of the conditions, the price. You've lowballed my initial offer. So what this says that what you've legally done is you have not accepted my offer. You basically made a new offer, and now the roles have reversed again. And now I'm the person who made the original offer. I'm in the position of deciding whether I'll accept your counter offer. And only if I accept it will we have a contract. So those are some of the rules that deal with like the formation of contracts. We also have some rules that deal with the performance of obligations, like once you have a contract. Um, so a lot of contracts, like I said, that they're actually pretty much all contracts. They're an exchange of promises. Like I'll do something in exchange for which you'll do something. Those are what we call obligations. And sometimes the contracts they'll stipulate things like the time of performance, like when each of us are supposed to do like whatever we're supposed to do, and what happens if one of us is late, if there's a delay. So Article 412 deals with that. I'll just read it here. It says, 1, if a fixed due date is assigned to the performance of an obligation, the obligor is liable for delay from the time that due date arrives. So if we put in the contract like I'm buying your car and you must deliver it to me on February 1st, and we set an exact time. If you're late in performing that obligation, like you deliver it a week later, you're liable for any harm that's caused to me. So I could sue you, assuming that delay was important and that it cost me something, like not having that car for say a week. So if you put a time in the contract, you're obliged to stick to it, and you might be sued. I mean, you might not be. In that type of case, it kind of depends, like whether the delay caused any harm to me. If not, then I really can't sue you. I could sue you, but I wouldn't. I wouldn't win any money if I did, so I wouldn't actually sue you. But anyway, that's the first rule. 2, if an uncertain due date is assigned to the performance of an obligation, the obliger is liable for delay from the time when the obliger receives request for performance after the due date arrives, or the time when the obliger becomes aware of the arrival of that due date, whichever comes first. So this deals with the situation where you haven't actually set like the exact time or date when in your original contract when you're supposed to perform an obligation, but sometimes like the other party, like after the contract has been formed, you will decide upon like a date when you're supposed to do something. The other party will notify you. like in our example, like if I say I'm going to, or yeah, I forget who's who, but if I'm going to sell you my car and you buy it and you pay me, and at the time of the contract, we didn't decide on like what date I was supposed to deliver the car. But later on, you say, okay, please deliver it on Tuesday or whatever, and I receive that, and I say okay, then I can be liable for a delay after that. And then 3 is like if no time limit is assigned to the performance of an obligation, the obliger is liable for delay from the time obliger receives the request for performance. So if we haven't set any sort of delay, any sort of time limit for the performance of an obligation, it's basically up to one party making the request for performance, and that sets the time. Sometimes performance of an obligation can become impossible. That's one impossibility of performance. 412-2 sub 1 says, if the performance of an obligation is impossible in light of the contract or other sources of claims and common sense in the transaction, the obligee may not request performance of the obligation. The obligee is like the person who is owed the performance, and the obliger is the one who's supposed to do it. So sometimes, like, for various reasons, after a contract is entered into, it becomes impossible for one party to perform an obligation based on one of these reasons. If it's actually impossible, the party that is owed the obligation may not request the performance of that obligation. So you sort of like you can't force me to do something that it's impossible for me to do. Article 415, actually I won't read this in full, but compensation for loss or damage due to non-performance. So basically, if you fail to perform an obligation that you're required to do, including like that one I just talked about, like because it's impossible, if we're talking about the impossible situation, like I can't be forced to do the thing that's impossible, but if that impossibility is due to something that was my fault, you can sue me for damages, for money, provided that it wasn't like your fault as well. Oh, and this applies not just that, but any sort of non-performance on my part, or your part. If we fail to perform our obligation, money damages are what you can sue for compensation for any harm that you received because the other party didn't do the thing they were supposed to do. Finally, we have cancellation, cancellation of a contract. So this is when you want to like terminate like a contract that you already have, like the end of the contract. So Article 541 says, if one of the parties has a right to cancel in accordance with the provisions of the contract or law, the cancellation shall be effected by manifestation of intention to the other party. 2, the manifestation of intention under the preceding paragraph may not be revoked. Hold on. Sorry, I got a little interrupted there. So I forgot where it was. If one party has under Article 540 here, where it says if one party has the right to cancel either under the contract or under law, they do that by manifesting their intention. So manifesting their intention could mean like just saying something, like I want to cancel, or otherwise communicating in some way that could be interpreted as like they're intending to cancel something. So you can cancel if you have a right under the contract. That means the contract itself says, like, has a provision that you've written yourself, or you and the other party have written, which says either party may cancel at any time, or party A may cancel under such and such a condition, or something like that. So the contract itself might have a provision that says when you're allowed to cancel, or it might not. But if it does, that's what this refers to. Or law, it says, like contract or law. Law means other rules of law, including a couple that we're going to see after this slide, give parties the right to cancel under certain circumstances, and they can exercise that. So one of those examples of having a right under law to cancel a contract is Article 541, provided by 541 of the code, which is the right to cancel for delayed performance. Here it says, in cases where one of the parties does not perform his or her obligations, if the other party demands performance of the obligations, specifying a reasonable period, and no performance is tendered during that period, the other party may cancel the contract. So, so basically, if the other party hasn't performed what they're supposed to, and you've asked them to, and you've given them a reasonable amount of time, and they still haven't, then you can cancel. Even if the contract doesn't say you can cancel, this rule says you can cancel the contract. 542 it deals with kind of like following on the previous one, is a time of the essence cancellation. It says, in cases where, due to the nature of the contract or a manifestation of intention by the parties, the purpose of the contract cannot be achieved unless the performance is carried out at a specific time and date or within a certain period of time. If one of the parties has failed to perform at the time the period lapses, the other party may immediately cancel the contract without making the demand referred to in the preceding article. So in the preceding article, 541 says, if you demand performance when the other party hasn't done it, and you give them a reasonable amount of time, and then that time lapses and they don't do it, then you can cancel. This is saying, like, when giving them that extra period of time would be unreasonable, you don't have to, you can cancel immediately, but only in that type of circumstance. The typical example of this would be like if I'm getting married and my wedding is on like June 1st, and I hire a photographer to take pictures of my wedding on June 1st. That's a time of the essence contract. It means that my desire to pay a photographer only applies on that one day. And so if the photographer is like late on the day of the wedding, I don't have to like notify them. I'm giving you like 1 week to take my pictures. That would clearly not make any sense, because I need the contract is only valuable to me on that very exact time. So if they're late or they don't show up, I don't have to give them reasonable notice. I can just cancel the contract right away. Now the effect of cancellation, if you do cancel a contract, that's what happens. Article 545 states that if one of the parties exercises his or her right to cancel, each party shall assume an obligation to restore the other party to the other party's original position, provided, however, that this shall not prejudice the rights of any third party. And skip a bit, and in part 3, the subsection 3, the exercise of the right to cancel shall not preclude claim for damages. So this means if I do cancel a contract, or if you cancel it, anything that we've given to each other or done for each other, we're supposed to sort of like make each other whole again. Like if I sold you my car for $1,000,000 yen, and for whatever reason you have a right to cancel that contract. Like maybe in the contract I say, if you're not satisfied with this car within the first 30 days, you may cancel it at any time, or within the first 30 days. You decide you're not satisfied and you cancel the contract. To put ourselves back into the original positions, it's kind of simple. You give me the car back, I give you the money that you paid back, and we're both in the same situation we were, as if the contract had never happened. Sometimes that's not actually possible to fully like do it like that. Like if I sell you like a bottle of soda, and you decide, and you have a right, you drink half of it, and then you decide you're going to cancel the contract, and there's some weird provision put into the contract for some reason that allows you to do so. You cannot give me like the half of the soda that you've already drank, so you can't put me back into my original position. When there's something like that happens, and that's kind of that specific fact would not result in litigation, but something like bigger scale would. We usually have we usually substitute money for the thing that you can't return. And then also this third part, subsection 3 says you can, in addition to like returning each other's like to your original position, like as best you can, like with money if you can't return like an actual thing, or if like I've expended labor and you can't give me my labor back, it's already done, so you have to pay me some sort of compensation for that. That's what this third one is for. Like maybe we've suffered damages over and above that. Like for example, and I can still sue you for not just to give me back like whatever I gave you, but also to compensate me for harm as a result of your doing something bad. Like I mean, maybe in the example of the wedding photographer I mentioned in the previous one, like if I hire a wedding photographer and they don't come to my wedding and nobody takes pictures, I can cancel the contract and I could get a refund of the money that I paid them. But maybe that's not enough to make me happy, because as a result of their failure, I will never for the rest of my life have pictures of my big day. And maybe I want to sue them not just for the money I paid them, but also some compensation for that harm that their failure caused. So so you're allowed to sue for harm in addition to just being put back to your original position. So I'll talk here just about a few cases which illustrate like some of these rules we've been talking about. So the first one is this Nihon Grando Rekodo and Ito as the Nagoya High Court case from 1970. This is there's English translations of these in the materials. This is the English American who translated it put this name on it. It's not what it's actually called in Japanese. It's a Nagoya case, a local case, so I like it. Well, not just for that reason, but it's the Nagoya Singer case. So this case dealt with, and the question, the legal question that's of interest is, when does a contractual provision go against the general good faith and public policy provisions of the Civil Code? Like those ones I mentioned earlier, that courts, I said sometimes when there's a provision in a contract that might be like grossly unfair or might go against public policy, courts will not enforce it, even if the person, it's otherwise like a valid part of a contract. This is an example of that. So this is a Nagoya singer named Ito, and back in the 60s. He was not super famous, like I guess like local Nagoya celebrity type famous, like kind of so. He signed, but anyway, he's a singer, professional singer. He signed a contract with this Nihon Grand Record, which was like it's a record company. And I mean the basic agreement was, Ito will record records and do other things like performing concerts and these sorts of things. And Nihon, he promises to do that, and then Nihon Grand Record, they will pay him some compensation when he does so. So that's sort of, and there's lots of like specific rules in the contract, but that's sort of like the general bargain that they had. But one of the provisions of the contract, the specific rules, was that after the end of the contract, so it's a contract for a fixed period of a fixed term. After the end of the contract, like he would, I forget the term of the contract, a couple of years, he'll produce a certain number of records and perform at some concerts for this period, and then the contract would finish. There was a provision that said, like at the end of the contract, for a period of a year, it's an exclusive contract that he is not allowed to perform concerts or other things for anybody else. It's like he works for them, and if he breaks that provision, if he goes and for example appears in a concert that wasn't arranged by Nihon Grand Record, he has to pay 5 million yen. That's a penalty. It's a penalty clause. And so anyway, he gets hired. He gets his contract. He performs concerts. He records albums. And the company, promotes the concerts and sells the albums in stores, or sells them to stores. The stores sell them. And it's not like he's not like a super all-star breakout guy. They sell a couple thousand records and gets kind of like okay attendance at his concerts. But so it doesn't make a lot of money on this contract. Neither side does. Ito, though, one day he goes on a TV show, CBC, like Chubu Broadcasting Company, like one of our local TV shows stations even now, has like a music show, and he appears on it and he sings one of his songs, and he did that outside of his contract. It was not arranged by Nihon Grand Record. So by appearing on this TV show, he was breaching this rule in the contract that said, you'll only appear in concerts and stuff that we organize. So they sued him, and the rule in the contract said, if you break the rule, you have to pay 5 million yen to the record company. 5 million yen even now, but 1970, those are like a lot of money. So they sued, and I mean, in terms of like establishing that he had broken the contract, is very, very clear he had. But that issue was like the court his defense was like, yeah, I might have broken that provision, but this rule that's in the contract which says I have to pay them 5 million yen just for breaking that rule, it's an abuse of right. They're trying to abuse a right that they have in the contract, and the court should not enforce that. And the basis for that was simply that the actual harm caused to the record company by him, going on this TV show was very, very trivial, if it existed at all. The court noted, like the number of records that were being sold by this guy. I mean, they weren't very high anyway, the harm it was really hard for them to actually, the company to actually show, yeah, him breaking that rule in the contract actually caused us some kind of harm. What was the harm that was going to be caused? Did it cause you to lose revenue from selling his records, or from booking him in concerts? They couldn't really show that, and they were basically just sort of saying, yeah, well, doesn't matter. Contract says he has to pay us 5 million yen. He has to pay us 5 million yen. And the court declined to enforce that, and basically on the ground that it was very, very disproportionately. It would have been like several years worth of income from this guy for like a relatively minor breach of a contractual provision. And so the court held that no, us enforcing a requirement to pay 5 million yen as a penalty for like a fairly minor breach of a contract, that would constitute an abuse of right, and we will not do that. So sometimes the courts, this is an example of like the courts, using those general provisions in the code where they feel like, yeah, technically, the record company is right, like the contract actually does say that, but it would be really, really unfair under the circumstances to actually like enforce that against this person. So they'll use those provisions to get to that conclusion sometimes. This other case, Kono and Otsuyama, a 1982 Tokyo High Court case. This is a case about gift contracts. I didn't talk about this. So I mentioned earlier, like there's lots of different rules that apply to lots of different contracts. Some of them are, one of those is gifts. Gifts are like different from other types of contracts in that they're not an exchange for an exchange. Like it's actually like a one-sided exchange. Like I will give you something, and I don't expect you to give me something, right? I'm giving you something. So in the common law system, like in Canada, the U.S., like we don't treat gifts as contracts because we require there to be that sort of like exchange of promises. But in civil law countries like Japan, sometimes like a promise by one person can be considered a contract, a promise to give something. So Article 549 of the code says gifts become effective by manifestation of intention by one of the parties to give a certain property to the other party gratuitously, like for free, and the acceptance by the other party thereof. So the elements are kind of similar. I think it's like, I will give you something and you accept it. there. Now I have a contractual obligation to give you the thing, even if I haven't handed it over yet. So this is kind of like an interesting case. It's like the two parties. I think it was Kono. I get the names mixed up, but the plaintiff in the case was like a businessman, like a salaryman in Tokyo, like back in the 70s. And the defendant was his girlfriend, no, ex-girlfriend. And they had met. She was like a bartender at a club in Ginza in Tokyo, and he was a customer there. And he would go to this bar and drink as you do at bars. And he kind of like the two of them kind of, I guess, hit it off or something, and they became like a dating couple from that thing. But anyway, when he was going to the bar, he had like a bank card, and he gave it to her, not as his like in a boyfriend girlfriend, but in like a customer bartender context, to pay his tab for all the drinks and food or whatever he was buying. He was like a regular. And so she kept it. Then they started dating for like an extended period, like a couple of years, I think. And she kept his card. They would go on trips together. It's kind of don't need to do all the details, but they had like this long relationship. They would go on trips together and stuff like that. And he would give her gifts. Over time, like as the relationship was going, like she still had his bank card. Initially, she was just using it as the bartender to pay his tab. But as the relationship like blossomed, it became permitted for her to use that bank card for personal stuff, like to buy things for herself, like and for her to take money out of it, like not as a bartender, but as his girlfriend. And he knew, and he let her keep it, and he sort of acquiesced to that. He was okay with her doing that, and so there's this new arrangement over like use of the bank card. Anyway, fast forward like a little later in their relationship. One day, yeah, I find this like part of the story kind of amusing. He has like he has a roll of film like from a camera, like back when cameras used film, and he asked her as a favor, not again as a girlfriend, not as a bartender. Could you please, like, are you going to the Photoshop? Could you please have them develop this film, like to turn it into pictures? And she said yes, and she went to do it. Big mistake, because like turns out he was married. He had a wife, and the roll of film had like pictures of him with his real his wife and him, and she didn't know that. She didn't know that he was married. And she found out by like, picking up this packet of pictures at the Photoshop and looking at it, like, who the hell is this? And so okay, sorry. What happened then was she got mad, as you can imagine, and I kind of respect her for this. What she did afterwards was so she finds out that he's married, and like he's technically not cheating on her, he's cheating on his wife with her, but and he'd been lying to her like the whole time, not telling her that he was married or anything. So to get revenge, she still had his bank card. So what she did was she went to the bank and took all of the money that was in the account out, and it became hers. And then kind of smart of her. And then after that, she confronted him and said, who is this? We're through, and she broke up. So that's the end of the relationship. But the lawsuit starts when he finds out that, oh my God, like he had a lot of money in that bank account, and it's now empty. And so he sued her. For the money that she had taken out of the account. So why am I telling you this long story? It's because it becomes a contract dispute, a dispute over whether this was actually a gift contract. So here it says like the gifts again, going back to the rule on the screen. Gifts become effective by the manifestation of intention by one party to give a certain property to the other gratuitously, and acceptance by the other party thereof. So the court had to decide, like, among that like story that I've just told you, with respect to the bank card, at some point, had that gone from being like initially he had given it to her clearly not as a gift. Clearly it was like, I'm a customer, you're a bartender. I give you this card, I'm not giving it to you, I'm letting you use it for the purpose of paying, for my drinks and stuff. Not a gift. But over the course of time, they started this relationship, and she starts using it to buy stuff and for herself, and he knows that, and he lets her do it, and he starts treating it like it's kind of like her gift, her bank card, that she has like full rights to take money out whenever she wants. At some point in that transition from the first to the second, did this thing become a gift that was effectively given to her? Like at no point did he say, I give you this card as my girlfriend or whatever to use it to buy anything you want. He never actually said like that, those words that you normally use to like very clearly indicate that you're giving someone a gift. But it's like this manifestation of intention. It is sort of like his acquiescence, his allowing her to do these things, knowing that she was doing it, and approving of it, like not objecting at least. Was that sufficient to create a manifestation of the intention to give her the card, and the card, by implication, the money that card would, the bearer of that card would be entitled to, as a gift to her. And the court held yes, it did. That manifestation of intention to give can come from behavior, and it doesn't have to be an explicit statement or anything like that. There was enough in there to indicate that he intended for her to have it. So that's why I say it was like really smart of her to take all that money out before she confronted him, because if she had just given the card, the license that she had to take the card out was hers so long as she was in possession of the card. The gift is the ability. It's not the physical card itself, it's the ability to take money out of the account. That's something that as soon as he gets the card back, it's no longer hers. So she was kind of smart to exercise that before confronting him. So anyway, fun case. Another case. There's actually two cases that I want to talk about. Is what I call bizarre clauses in idle contracts. This is two cases that happened in the Tokyo District Court in 2015 and 2016. Both of these deal with contracts between a talent production company that runs idol groups, like teen idols who sing and dance and stuff like that, and their performers, like the members of their groups. Now, these I say they're bizarre clauses in idle contracts because in that industry, those types of contracts between the production companies and the performers will oftentimes have a clause, and the way it's written, it seems to differ from company to company. But basically, the basic rule is, you performer are not allowed to date anyone. No romantic life for you. It's basically a contract. Otherwise it's kind of like a normal contract. Like you're a singer dancer, so we're going to pay you to perform and sing. You do concerts, and we'll use your image on merchandise, and we'll record albums and stuff like that. In exchange which, we'll pay you money. But they put these I'm going to call them bizarre or weird provisions that you don't find in I don't know, probably not many other contracts that it's like really deeply personal. Like you cannot have any sort of relationship with anybody for the duration of this contract, and if you do, we will sue you for money. And some of them similar to that Nagoya case with the singer from the 60s that I was talking about earlier. They might have provisions that liquidated damages, like a set penalty that they'll impose on them. And so there was like 2 cases that dealt with that type of provision in an idle contract. There's like two different companies, 2 different like singer or dancer or whatever, but they both came to the same court. And so in the first one, this Tokyo 2015 Tokyo decision, a 17-year-old idol was forced to pay her company 650,000 yen in liquidated damages for breaching a dating clause in a contract. And then a few months later, the same court had like a similar case, almost not quite identical, but almost identical facts, but it came to the opposite result. Basically, in the first case, the idol lost. The court held that, yeah, a no dating clause is okay, and if you break it, we'll charge you money, or we'll let the company charge you money. We'll enforce it. The second one, the court said nope and nope. So it's kind of interesting to look at these cases to see like why the courts reach these opposite conclusions. I put a translation of the second case in the materials. I translated it a few years ago just because I thought it was interesting. And I have a little discussion about the first case too. So in the 2015 case, so so he had his contract between it was a 17-year-old girl and a production company, and she was gonna join this like I think a 6-member idol group that would like dance and sing and stuff. Then it had so when you're 17 years old, you need your parents to sign a contract for you. When you're basically you're still considered a child. So her parents had signed as her guardians. So the contract contained that provision. I forget the exact phrasing, but it was like you may not have any like romantic relationship with anybody during this time period. I guess they put those in there because like the fans of those groups like want everybody to be single. It's just like I don't get it, but anyway, so she joined the group. She started performing, and it sounded like it's like a really mean group. Like at one point, like she like went on a date with some like boy like boy fan, and they took some pictures together, and then like. Sounds like one of those like Mean Girls type of situations, like the movie Mean Girls, where it's like one of the other group members found out and like got a copy of the picture and like ran to the boss and said, "Oh, look, like this one, she dated somebody." Anyway, when the production company found out that she had dated somebody, they canceled her contract. They terminated her, basically fired her, and they actually they disbanded the whole group. So that's what they do, I guess, when somebody goes on a date. It's just so stupid. Anyway, but they didn't just cancel her contract and fire her. They then sued her for money in addition to like that, because the contract said it had one of those like penalty clauses that if you break this provision, we can sue you for damages. We can sue you for like X amount of money. And so the court, the judge in this case, you know, this is the dispute he had. Should I enforce this contract that bans like a 17-year-old from you know falling in love or anything? Seems like so cruel, right? And not just like, you know, and should the result of her breaching that contract, if I find that this is like a valid contractual provision, should I also allow the company not just to like terminate the contract, but actually sue her for hundreds of thousands of yen? And the court found for the company, basically the company said, you know, as a result of her breach of this contract, we had no choice but to disband the whole group, and therefore, you know, we lost some revenue from, you know, T-shirts and concerts that we canceled and stuff like that. We just threw all that stuff out. And the court just said, yeah, no, that's a valid contractual provision. Yeah, 17-year-old paid this company 650,000 yen. And I really don't like this case because what's remarkable about it is that at no point does the judge ever address this question of like have any sort of quandary about like enforcing it. Like, is this a sort of provision that we should enforce? Like, it's something that's so deeply personal that seems to like restrict someone's basic right to do like a normal thing that's kind of like necessary for human happiness to like form these relationships and stuff like that. Of course, like, no, whatever. That doesn't even touch on that. It's like, yep, you got a contract. Provision looks good. We're going to enforce it. Several months later, like I said, there's a second case that comes to the same court, different judge, but the same court, Tokyo District Court. Very, very similar facts. Although it's a little bit different, but the facts are like, again, you have like a teenage girl who signs a contract with a talent agency that produces like idol groups. Also, like, not the age of majority, so she has her parents like act as guarantor or like representatives of her. She's a little older, she's like 19 in this one, but so 20 is the age. In this case, so they sign the contract. She joins the group, starts singing and dancing, blah blah blah. So that part of the story is similar. There is a difference in the facts after that, though, is that in the previous case, it was sort of like just like a one-off thing this girl had with somebody. In this case, the defendant, she had like a regular boyfriend who, just like dating or whatever, nothing unusual, but was keeping that secret from the company. But unlike in the previous case, the company never discovered that while she was a performer. Rather, what happened was she started working for them, and you can read it in the decision, and basically decided, like, not because of this no dating clause, but just because of the job, she decided, this job sucks. I hate it. I don't want to be an idol. Get me out of here, kind of. I guess, like, who knew? Being an idol is not a good job. The pay is very, very low, and it's also infrequent. Like, she describes in the evidence in the case that some months you have lots of concerts and you make like a bit of money, then they'll go like a couple months with like no concerts and they don't make any money. So it's like their income is not very high and it's like infrequent. It's very, very like demanding physically and like psychologically and stuff like that. And so it's like one of the jobs where like just like not everybody is cut out for it. In fact, most people would probably not like that job unless you become like mega like famous, which is only like a small number who do. So anyway, she goes through that lifestyle for a while, decides I've had enough of this. I'm gonna quit. And so one day she writes an email to like the company saying what I just said, like I've thought about this and I don't want to be an idol anymore. I want to cancel the contract. I want out of this. And they don't know that she has a boyfriend, so it's not relevant at this point. And so the manager comes back and says like, okay, well, we've got I understand what you're saying, but we've got some concerts and like we don't want to let you quit. So how about we let you quit next year? And they give like a date like in the future. They give a kind of like non-committal response that doesn't really acknowledge that she's quitting. And so then a little while later, after that response, there's a concert like a few days later. She doesn't show up for it, and so like the other members of the group do it without her. And then like a day or two after that, she sends a message to the company, which is much more direct than her first one, which is, as of this date, I quit. very, 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 very clear. Not the sort of, I don't like this job, I think I want to quit. It was like, no, as of this date, take this as my notice that I am quitting, and I'm canceling this contract from now on. So the company sued her to based on her quitting, actually, not based on her quitting and not on her having a boyfriend. But after they find out that she's quitting, they find out that she had a boyfriend, and so part of the lawsuit becomes, well, okay, we're suing her because she quit, she canceled the contract, and she wasn't allowed to cancel the contract, and also she broke a provision of the contract, like the no dating clause, and we're suing her for that too. So legally, because it was in the first case, the party who canceled the contract was the production company, and it was just solely basing it on her violation of that no dating rule. In this case, it's like the singer performer herself who's decided, I'm going to cancel the contract, and I'm gonna try to, and if she wants to do that, she has to have some sort of legal basis, right? We saw that in the civil code provisions on canceling contracts. So she needed some sort of hat to hang her that sort of argument on, so peg to hang that argument on, legal peg. And the company is suing her now, saying you don't have that legal argument, you don't have that argument, you canceled when you were not allowed to, and you were breaking the provisions of the contract. So we can sue you for all of the harm, like in the previous case, all of the harm that flows from your decision to quit, and also for your having a boyfriend. And in addition to that, because they're mean, they also sued her boyfriend and her mom and dad. Actually, this I didn't mention, the first case, they also sued the mom and dad, because you had the mom and dad, the boyfriend had been somehow their argument was like, well, he was also breaking the contract. They didn't have a contract with him, so that's a really bizarre thing to argue. But he had been inducing her to breach her contract with them by being her boyfriend. And then the parents, they were suing for not having supervised their daughter enough to make sure that she didn't have any boyfriends. This is, I really do not like these companies, because this is just like a stupid argument to make. But anyway, so that's really like the legal situation. And so with respect, so the main question though was like, did she, the performer, have a right to cancel the contract when she did? Like, she sent this message like by email to the company. She sent two messages. She sent one which was like not too direct. It was like, I've had enough of this lifestyle, I want to quit. But she didn't say like, I'm quitting today or anything like that. It's like indicating an intention to cancel the contract, or quit, but not being a bit fuzzy on the details. And then the second one that she sent later, saying, I am canceling this contract today. Did one of those create the actual legal result of her canceling it? And that question turned on, what kind of contract did she have? So, and there's different rules that apply to canceling different types of contracts. I didn't really go through these, but the result could be different depending on the type she had. So if it was like an employment contract that she had, like she's an employee of the company, then like on the slide here, it's like on the left, Article 628 of the Civil Code tells you when somebody can terminate or cancel an employment contract. And that says, even if the parties have specified a term of employment, either party may immediately cancel the contract if there's a compelling reason to do so. In such cases, if the reason arises from the negligence of either of the parties, that party is liable to the other party for compensation or for loss or damage. So the main rule is like compelling reason to do so. I've underlined that there. So if it was an employment contract, she was within her rights to cancel it if she had a compelling reason to do so. If not, then if she could show that, then she could win. If not, she could lose. If the court decides, yeah, this is an employment contract. The contract itself didn't say that it was, which is why this is an issue. So she was there, so this would be good for her. On the other hand, it might have been this other thing on the right hand of the screen, which is a contract of mandate. A mandate is like not an employment contract. It's kind of like a somewhat similar relation thing, but it's like when one person hires somebody else, not hire like an employment relation, but pays somebody else to do a specific thing, and you're not in a employment relationship. You've given them some sort of direction to do something, but you're not entering an employee-employee relationship. And so contract of mandate has like a different rule if you want to cancel it. That's Article 651. So it says, I'll read it here. 1. A mandate may be canceled by either party at any time. 2. In the following cases, a party that has canceled a mandate pursuant to the provision of the preceding paragraph must compensate for damage suffered by the other party. Provided, however, this does not apply if there was a compelling reason for the cancellation, if the party, you can't really see it here, if the party cancels the mandate at a time that is detrimental to the other party. So, if we look at these two rules, like the employment and the mandate contract, both of them give a right to cancel if there's a compelling reason to do so. But the one thing that's different is like on the mandate side, this bottom one, it says, if the party cancels the mandate at a time that is detrimental to the other party. That is to say, even if, and that rule isn't on the employment side, what this means is if you've exercised your right to cancel that you have, if you do so at a bad time for the other party, they can sue you for any harm that they have, okay? Whereas if it's an employment contract, you don't have to worry about that. You can cancel any time. It doesn't matter if it's inconvenient for the other party. So in this case, the music company, the production company, their argument was, okay, this is a contract of mandate, and even if she had a compelling reason to cancel the contract, she couldn't cancel it when she did because that was at a time detrimental to us. Her canceling it, like when she did, we had concerts planned, we had like t-shirts, all this merch that we produced with her, name on it and stuff like that. And her canceling it then meant that, we would experience losses. We would have to cancel. We would cancel contracts, all these concerts, all this merch that we produced. We'd have to get rid of, and we would lose money on it. So they were suing based on that. Whereas her, her side would say, no, if this is an employment contract, that's irrelevant. Doesn't matter if we cancel at a time that was irrelevant for them. They can't sue us because 628 doesn't say anything like that. It just says that if we have a compelling reason, and as long as there's no negligence on our side, it doesn't matter. We can cancel anytime we want. So the court had to decide which of these two it was going to choose. And the court in this case held that it was an employment contract. Looking at it, like this is not, like a mandate is like kind of like I said, it's a work for hire where you just hire someone to do like one thing that you give them directions to do, kind of like you're not an employee, you're a contractor type of distinction. Court held, no, this is an employment contract. She had a boss that was giving her directions, and that's an employment relationship. So this is an employment contract, and so that means the judge's analysis goes based on 628, and they have to ask, well, is there a compelling reason for her to quit? And the court held, yes, there is a compelling reason for her to quit. And I'm paraphrasing here, but basically, this job sucks. That's a compelling reason for someone to want to cancel a contract. That's not what he said, but basically, all those things that I said, like this is what the judge cites in giving the reason, is that like this is a job with like low pay, long hours, infrequent, like unreliable, unpredictable pay, physically and emotionally and psychologically demanding, these sorts of things. And all of these things together constitute like can give someone a compelling reason to want to cancel a contract. And so she had the right to, and the company could therefore sue her only if it could show, and if you look at the second line of 628, if the reasons arise from negligence of either of the parties. Those reasons did not, they were not the fault of, they were not her fault. They were not the fault of her being negligent, right? This job sucking is just the way that job is. She wasn't doing anything bad or anything. And so analyzing it based on contract, the court held she was within her rights to cancel, and there was no negligence, so you can't sue. The fact that the cancellation happened at a time that was detrimental, like which would have been relevant if it was a contract of mandate, doesn't matter. This is not a contract of mandate. We're not applying that rule. We're applying the employment contract rule. And what I like about this contract, this case too, is that the court also addressed that the fact that there's a side argument, like not just about the cancellation, but about like her breaching the term of the contract that said you're not allowed to date. Unlike the 2015 case, like just a few months earlier, same court, like probably one of this judge's colleagues, who had just sort of like said, you know, whatever, that's fine. It's just like another contractual provision. This court, the judge in this case actually kind of addressed this question that I was like kind of raising earlier. Like, should courts really be like enforcing provisions like that, where it's like, especially when you're talking about like someone young, like a teenager who's not even old enough to enter a contract, and prohibiting them from, you know, doing something like just, you know, having a relationship. It seems like highly invasive. And impinging on, you know, personal freedoms that people have. And so there's this quote, this is my translation of it, that the judge kind of addresses that. It's like, having feelings for other people is part of the reality of being a human, and feelings of love are one of the most important of these. The appearance of such feelings in relationships between members of the opposite sex, and in particular having sexual relations, is a very important right one can choose for oneself that allows one to lead a better life. Being free to have a relationship based on mutual intent with the member of the opposite sex without interference is to be interpreted as part of the freedom to pursue happiness. That's a constitutional right. In light of this, at the very least, in seeking to prevent their idols from having relationships by bringing damages claims based on such contractual provisions, are considerably restraining their exercise of such rights. For this reason, the plaintiff bringing a claim against for damages against the defendant for having a relationship can only be interpreted as an act of the plaintiff's malice. So it's kind of like an abusive right type of thing. So the court in this case, unlike the previous one, said no. You know, in addition to like, you know, the analysis being a little different because it was her that had canceled the contract, they also like addressed kind of like the heart of the issue that I felt was really like missing from the 2015 case. So, so the net result of these two cases, like these are both lowercase decisions. So it's like the actual, it's possible that in the future, like similar cases might come up, and like we have like people being sued for having a relationship with someone based on one of these contracts. So it has, because you have the conflicting kind of like outcomes based on different fact situations and different judges applying the rule, did slightly different rules. So it's possible that this type of provision could still be enforceable in a court. In Japan, I'm not too sure, but at least I felt one judge kind of got it a bit right there. So anyway, anyway, I'm gonna kind of close it here. So that's my kind of introductory class on contracts. And I'm going to do one more lecture after this. We're talking about a specific type of contract, which is actually following on this. It's employment law contracts. We're going to look at a little bit more detail in that. That lecture will be a bit shorter than this one, but so I'll post that in a moment. So thank you very much.